everyone, we are from Koay and Partners. So today we are going to discuss the topic of forfeitures of bail bonds. From bail to forfeiture, from trust to loss. So before we dive into nitty-gritty of today's topic, so let me pose a question to you. Do you actually know what a bail is? So imagine that John has been arrested for voluntary causing hurt. So as this is a bailable offense, so it is his right to get a bail. So this bail is like a special permission slip that's given to him for him to leave the jail for a while waiting for the trials. However, he must promise that he will come back to the court when he's supposed to. So in academic way of saying, bail is like a temporary release of an accused person upon depositing sufficient security to the court and also an undertaking by the bailer. So the bailer is a person who agrees to be responsible for the accused by making sure that the accused will follow the bail conditions and also attend the court as required. So the purpose of this bail is to secure the attendance of an accused person at the court date to answer the charge against him. So if they do everything as they promised and also attend all the court proceedings, they will get their money back. But if there is any failure in adhering to the conditions of the bail, then the court may forfeit the bail bond and also the bail sum. In forfeiting the bail bond, we have to look at sections 404 of the Criminal Procedure Code. So it states that the court shall record the grounds of the proof of the bond and also may call the sureties to show cause why the bond should not be forfeited. So in simple words, it means that if the court has found that the accused has not fulfilled the conditions of his bail bond, so the court will make a record of why it believes that the bail bond should be forfeited. So the court will ask the surety to give an explanation and testifies to court that there were good reasons for the accused absent and therefore a penalty should not be imposed on him. So if sufficient cause is not shown and the penalty is not paid, the court may issue a warrant to attach and also sell the property of the bailer.
Worth noting that when accused fails to appear, the court must consider the questions in two stages. Firstly, has sufficient cause been shown against forfeiture? Secondly, if the answer to the first question is no, then are the circumstances such that the whole sum of the penalty should breaking the procedure down into steps. First of all, the prosecution need to prove the bailer or sureties executed the bail bond. Secondly, the bail bond must also be produced and proved by calling the registrar magistrate or president who granted the bail. Thirdly, the sureties must be given the opportunity to cross-examining all witnesses. Lastly, the sureties should give evidence and call witness to explain why the court should not forfeit the bail sum. Such procedure is well demonstrated in the case of Koay and another versus on. The circumstances for non-compliance of procedure is well illustrated in the case of PP versus Train Thai Truck, in which the High Court found that the magistrate was in error from the aspect of law for taking the shortcut to forfeiture bail bond without giving the opportunity for the bailer to show cause. Therefore, the magistrate was directed by the High Court to set a new date for the fulfillment of all requirements under Sections 404 before descending on the matters of forfeiture.
Now we'll be discussing on different situations which warrants forfeiture of bail bond. So in these following cases, the main reasons for the forfeiture of bail bond was that the accused person default in his appearance before the court and there is no sufficient cause shown to the court to justify such defaults. So for example, in the case of Mutamat anak perempuan Kaliapen against pendakwa raya, what happened in this case was that the appellant stood as a bailer for the accused who was charged for rape offence. The trial was adjourned to 11th of April 2005. However, on 6th of April 2005, the appellant and the accused were arrested by the police on suspicion of drug possession and they were both then remanded for 11 days, which is until the 17th of April 2005. The court held that the bailer cannot use the arrest to exonerate herself because it was her duty under the bail bond to inform the session court when the situation permit of that matter, which is after she was released from the arrest. So in this case, we can see that the bailer did not notify the session court in the absence of the accused immediately whenever it's permissible. Therefore, it can be construed that the bailer failed to show a sufficient cause and the bail amount was forfeited. Another situation warranting forfeiture of bail bond is when the bailer failed to take necessary and reasonable steps to get to know of the accused's whereabouts in order to secure his attendance before the court during the trial. So these can be seen in the case of public prosecutor against XUAN and another. In this case, the court held that the bailer failed to take sufficient steps to make sure that the accused would not abscond when he was aware that she and her husband intended going on a tour. For example, the bailer should have asked the accused the details of a tour in the first place. Hence, in this case, bailer did some measure of negligence in securing the appearance of the accused before the court. It amounts to insufficient cause, and the bail amount was forfeited. So therefore, it was a clear-cut case warranting a forfeiture
Now,
of bail.
let's move on to another situation where the forfeiture of a bail bond may take place based on the case of Ibrahim Saleh against public prosecutor. In this particular case, the court found that the surety was aware of her responsibilities and willingly became a surety for the accused. However, her decision to become a surety was reckless because she didn't know the accused and had lost contact with him for a period of 2 years. Moreover, she couldn't provide specific details about when and where she searched for him. Additionally, she failed to ensure that she obtained a Form 14 from a government doctor in a hospital or clinic to validate the accused's illness and the treatment he received. As a result, the court was left uncertain about the authenticity of the last medical certificate presented by the accused when he requested an adjournment. Therefore, if a surety fails to take reasonable steps to ensure the accused's attendance without a valid reason, as what happened in this case of Ibrahim Saleh, it constitutes a breach of their undertaking under the bail bond, and the bail bond may be forfeited. Furthermore, we also can consider the case of Yap Yin Kok against public prosecutor as another example of a scenario leading to the forfeiture of a bail bond. In this case, both the appellant and the surety failed to appear at the hearing. Instead, the surety's son attended the show cause hearing and submitted a letter stating that his father was in the United States and would return home at the end of July 1987. The son requested an adjournment to allow his father to appear in person. However, the court ruled that going overseas is not a sufficient reason as the surety didn't appear to make any effort to stay in touch with the accused or his son during his extended stay abroad. This lack of communication prevented the surety from receiving official information about the upcoming hearing, and consequently, the bail bond was forfeited, and the surety was obligated to pay the bail amounts. This case clearly demonstrates that when a surety who is overseas fails to make any effort to maintain contact with the accused, it can result in the forfeiture of the
Another
bail bond.
situations warranting the forfeitures of bond can be seen through the case of PP versus Ahmad bin Kasiran. In this case, the surety argued that the bond was bad in law as it does not specify a specific date of hearing for the accused person to appear before the court. Normally, the hearing dates are never mentioned in the bond, but a notice of hearing is issued separately. It is also crucial to note that during the applications of extensions of time for trial, the bailer was clearly notified that the court would grant them time until the next trial date on 15th April, in which to produce the accused, failing which they were warned that their bond will be forfeited. The court held that, although the bond in this case had been carelessly drawn up, the bond remained valid, since the duties of bailer in securing the attendance of accused was also clearly notified. Hence, their default of duty and failure to show sufficient cause on their default lead to the forfeitures of bail bond. As shown in the case of Owned versus PP, the bond was forfeited in the situations where the surety failed to fulfill the conditions of bond without producing the fishing vessel even the accused persons had presented to the court. In this case, 8 Thai nationals were charged at the Magistrate Court for an offence under Sections 15(1)(a) of the Fisheries Act 1985. The Magistrate Court ordered that the fishing vessel be released on a bond of 75,000 ringgit in one surety, and that the vessel be produced when so required by the court. On the trial date, the 8 Thai nationals pleaded guilty. However, since the surety failed to produce the fishing vessel to the court, the bond was forfeited.
Now, we will proceed with the situation in which bond can be set aside as there are sufficient causes. Firstly, by referring to the case of Balakrishnan, anak lelaki Vera Papan and others against public prosecutor, sufficient attempts were made by the bailier to secure the attendance of the accused person in court. Basically, they had gone to the house of the accused person and checked the whereabouts of the accused person with the family members and with their friend. Therefore, the forfeiture of bond was set aside in this particular case as the sureties had taken various active steps to procure the attendance of the accused person in court. Next, the case of public prosecutor against Chow Tai Chuan and another, whereby if it was proved that a surety was not informed of the hearing date, a sufficient cause was shown, and there shall be no forfeiture of the bail bond. Last but not least, the case of Koh Hong Guan and Moh Oi Hee against Regina, in which when asked to show cause, the sureties contended that the case was transferred to the session court without their knowledge. The court found that there was no breach on the part of the sureties and the order of forfeiture of bond was set aside. In conclusion, forfeiture of bond can only be set aside when there is sufficient cause. Without it, the court may forfeit the bail bond and the bail sum. Also, to recap everything, we had discussed the procedure to forfeit under section 404 of the CPC, the different situations that warranting forfeiture of bail bond, and the situation in which bail bond can be set aside. So that is all from our group. Thank you very much and bye.
We are the dreamers, we make it happen. Guess we believe it. Look who we are.